So, good morning, everybody. I'm Dr. Nauman Rayat, lecturer in law at Leicester Law School. I welcome you all to the second guest lecture of the guest lecture series of the Global South Network. For those who are new to the network, please allow me to briefly explain what the network is about. It's an interdisciplinary forum dedicated to examining interdisciplinary issues of the Global South and to inform policy making in that region. I'm the network's convener. Our today's guest is Justice Dr. Esmeralda Zahir. Justice Zahir is one of the first female judges appointed to the Supreme Court of Maldives. Prior to that, she had served as a judge at the High Court of Maldives. Justice Zahir pursued her law degree in Cardiff. Her doctorate was in international intellectual property rights from the University of Exeter, UK. Today, she will talk about reinforcing democratic values through online hearings, Maldives experience for around 30 minutes. The talk will be followed by a question and answer session where the attendees may wish to post their comments or questions anytime during the talk. Having this said, I hand over the floor to Justice Zahir. Over to you.
Thank you. Thank you very much. I would like to take this opportunity to thank Dr. Riayat and the Global South Network for giving me this opportunity to share our experience from the Maldives. It is an absolute pleasure to be here. By way of introduction, the Maldives is an archipelago consisting of 1,190 coral islands scattered across the ocean, of which 187 islands are inhabited. The country has a decentralized government, administratively dividing the country into 20 atolls and 4 cities. As early as 1932, we have had a written constitution. Our current constitution was adopted on 7th August 2008. The new constitution made a significant move towards the protection of individual rights and freedoms. Previous constitutions of the Maldives did not recognize the separation of powers and accountability, whereas the 2008 constitution, for the first time in Maldivian history, recognizes the judiciary as an independent power along with the legislative and executive bodies. Fundamental rights are enshrined in Chapter 2 of our Constitution, and it is the state's duty to ensure that these rights are protected and promoted. The Supreme Court of the Maldives was formed under the 2008 Constitution. Prior to that, we had the lower courts and the High Court. Appeals of High Court decisions were made to the executive under the previous constitution. Irrespective of the constitutions that we have had, a persistent issue for the Maldives has always been access to justice. Our unique geographical setting only exacerbates this problem. People living in different islands may have access to their local magistrate courts, which are based in those islands. However, many people are faced with challenges in accessing the appellate courts, especially with the assistance of legal counsel, most of whom are based in the capital city of Male. Even where legal counsel have been appointed by parties to represent them at appellate courts, if they do not physically attend a court hearing themselves, there generally tends to be a bit of a disconnect between the courts and the parties to a hearing. Under the current constitution, the Maldives has a 3-tier court system. The apex court is the Supreme Court, followed by the High Court, and finally the lower courts. The lower courts are first instance courts divided into 2 categories, which are the magistrate courts and the superior courts. The magistrate courts are typically based in all inhabited islands with a limited jurisdiction over civil and criminal matters. The superior courts have jurisdiction over all matters in the Male area, as well as matters that the magistrate courts do not have jurisdiction. The superior courts are the criminal court, the civil court, the family court, and the juvenile court. We also have a drug court that mainly focuses on the rehabilitation of offenders. The history of remote hearings. As is the case with any country, the Maldivian courts had also relied on the traditional physical hearings, where parties or their representatives were required to make a physical appearance in court. The geographically dispersed islands, as beautiful as they may be, provided thorny issues for the courts. Taking witness statements and conducting hearings of parties who resided in different islands were often costly and time consuming. This was especially the case at an appellate level, where even appeals of decisions of magistrate courts came to the High Court based in Male. Traditionally, the appellant bore all expenses of an appeal. The appellant would also be required to pay a deposit to the High Court for all expenses for the respondent if that party resided in a different island. In other words, the appellant would pay for the flight tickets and all transport costs and accommodation and daily subsistence of a respondent. This amount would be reimbursed to the appellant if he won the case. Since the 1990s, it has been known for the courts to coordinate with each other, especially with regards to certain types of witness statements in civil matters. For instance, a magistrate court may request the civil court in Male to take the statement of a person residing in Male regarding a particular issue. The civil court may make similar requests to a magistrate court in the island in which the person resides. Fast forward to the 2000s. The High Court had started the practice of audio conferencing. By 2013, the High Court had started video conferencing, which was convenient for all parties concerned. The scenario here is that both audio and video conferencing was actually the connection of two different courts. The High Court would typically connect via audio or video conference to the magistrate court where the party or parties reside. There were instances where a party may appoint legal counsel in Male, but still insist on attending the hearings virtually from his island. In such cases, whilst the legal counsel appear physically to the High Court in Male, both the appellant and the respondent are at the local magistrate court and appear at the High Court via video conference. This was the beginning of a colossal change to how we conducted hearings. Technically, this was the beginning of remote hearings for us, where parties to a case were located in different courts in different parts of the Maldives. It was cost-effective and reduced the issue of getting the appellant to pay large deposits and in turn get the respondent to physically appear at the High Court. The corollary of this was the speedy disposal of matters than would have been the case in the event of physical appearances in court. The coronavirus pandemic and the upsurge of virtual hearings. Now, remote hearings is not a new concept to the Maldives, but come the corona pandemic and lockdown measures, we simply could not shut down the courts. Whilst taking into account the safety of court staff, the Supreme Court decided to keep physical interactions to a minimum level. Appeals and responses were lodged at the court via email. The registrar's correspondences to the parties were entirely via email and phone calls. As a result of lockdown, we decided to conduct hearings via Microsoft Teams. In contrast to the remote hearings that the High Court held previously, the Supreme Court's virtual hearings involved several different locations. Whilst the usual 3 judges on the panel would be joining from their respective homes, the court officer, the IT team, the legal officer, the parties to a case, and their respective legal counsel all joined from their homes. So, in a given case, on average, we would have at least 8 people joining the virtual courtroom from 8 different locations. One of the concerns that we had with this method is the obligation under Article 42 of our Constitution. Article 42 basically stipulates that everyone is entitled to a fair and public hearing, that all judicial proceedings in the Maldives shall be conducted with justice, transparency, and impartiality, and that trials of any matter shall be held publicly, subject to certain exceptions. Moreover, Article 42 sub D emphasizes that all judgments or orders of a court shall be pronounced publicly unless the case falls under one of the exceptions. The exceptions to an open hearing are in the interest of public morals, public order or national security, in the interests of juveniles or victims of a crime, or in any other circumstances where publicity would prejudice the interests of justice. During lockdown, the dilemma that we had at the Supreme Court was, if we were to have hearings via Microsoft Teams, how could we ensure that those hearings were accessible to the public? We decided that in order to fulfill our obligations under Article 42, the most feasible option was to introduce a YouTube channel of the Supreme Court where anybody could watch the hearings live, or even watch them later should they wish. This was the perfect solution for a court that had major budget constraints. Moreover, the vast majority of the population is familiar with YouTube, and the Supreme Court hearings are easily accessible to all. Separately, we also uploaded our videos on Twitter. Judgments are also live streamed, and within a couple of hours, signed copies of the judgment are emailed to the parties and uploaded to our website with the link shared on Twitter. How it actually works. I have come across colleagues from other countries who regard online hearings with some skepticism. I am not entirely sure why online hearings are not deemed popular in certain jurisdictions. I have heard that some prefer to see people face to face. For me personally, in physical hearings, parties are seated quite far away, and I do not always see their faces and expressions. Whereas in an online hearing, I do not miss a single twitch or wince, and I'm sure it works the other way around as well. It is possible that online hearings are not deemed popular because of the notion that it may be challenging to control and uphold courtroom procedures and etiquette. During the pandemic, when we first started hearings on Teams, the first step would be to send the summons by email to both parties, along with a copy of the Supreme Court's Teams guideline. The guideline has details. Oh, you found the YouTube channel. That's great. The guideline has details on how to download and join Teams, along with guidelines on how to choose an acceptable background for the hearing, preferably to sit by a wall and ensure that we can clearly see the party's face and that there's no unnecessary extra light in the background. To choose a quiet place free from distractions or interruptions. If the device does not have sufficient battery power, to ensure that it is plugged to a power outlet throughout the duration of the hearing, and so on. Both the guideline and the summons have additional instructions, such as wearing acceptable clothes when appearing in court. Usually the requirement is to dress smart, that no one else shall be allowed in the room during the hearing, that no party can walk out in the middle of the hearing and may only speak once permission is granted, that the video should be turned on at all times to keep the microphone on mute at all times, unless when given the floor, and generally to respect courtroom etiquette. The instructions also remind parties that disregard of general court rules could result in contempt of court. Now, when we first started online hearings, one day before the hearing, the Supreme Court staff would call the parties for a test hearing. In the test hearing, should the parties require assistance in using controls in the application, our staff would direct them. For example, how to switch on the camera and microphone on an iPhone and how to bar calls whilst in the Teams hearing. So we're actually quite specific about the device that they use. In the test hearing, staff would again reiterate instructions written in the summons. Now, all Maldivian courts in physical hearings have had the tradition of making an announcement prior to the commencement of a hearing. For example, how to address the judge, to speak only when given the floor, to treat everyone with respect, and how disregard for any of this could result in contempt of court. Some may find this a bit harsh, but culturally, we are very laid back people. Our population is small, especially in the islands. Everyone knows one another. I believe the tradition of making this announcement in the physical courtroom began in order to give people a gentle reminder that they are in court and that court etiquette should be respected at all times. So during the online hearings, our regular announcement was modified to reflect that no one else should enter the room once the hearing commences and to respect the usual courtroom etiquette. So even though this would be an online hearing where the parties are joining from the comfort of their own homes or law firms, the minute they join the virtual courtroom, they would be treated as if they were physically inside the Supreme Court. I think constant reminders of this have worked well in ensuring that hearings went smoothly. Even if parties have joined from different countries or even while at sea, they had fully recognized that they were inside the courtroom once they logged onto Teams. I would say cooperation from the parties played an immense role in making online hearings a success. In a couple of judgments, I have experienced dissatisfied parties simply disappearing offline or switching off their cameras. But parties always cooperate when reminded that they are at the Supreme Court and that court rules apply. At this juncture, I think that I should also note that judges and courtroom staff are connected via a WhatsApp group dedicated to live hearings. All communications regarding the live hearing are made in this group. For example, if IT would like a party to adjust the camera angle, instructions would be shared in the group, or even general instructions to the legal officer, etc. With regard to persons with disabilities or PWDs, we do not often come across such situations. However, where an elderly party requires assistance in joining an online hearing, we ask them to identify someone who can help. Usually, it would be a son or daughter. Court staff would usually liaise directly with the assistant. When a person is experiencing difficulties in using Teams or even have problems with the internet connection, if they are in Mali, we ask them to physically appear at the Supreme Court. And if in an island, we coordinate a convenient time for the local magistrate court and ask the party to appear there. So, except in the case of lockdown, the Supreme Court has always been open to parties experiencing difficulties in using Teams. In such a situation, courtroom staff would assist the party in joining Teams, whilst the other party to the case would join from a different location. The judges would join from their respective chambers. Physical hearings are given preference where a convict complains of not having access to their lawyer or require a translator. Our live streamed online hearings was such a success that we ended up installing cameras in our physical courtroom as well. So COVID changed us a lot. So how does online hearings contribute to reinforcing democratic values? In comparison to the physical in-court hearings we have had, the level of transparency and public trust that we have gained from online hearings is colossal. Parties to a case or any member of the public may watch Supreme Court hearings live. The live hearings are saved in our YouTube channel, as you have discovered, and may be accessed by anyone at any time. This is a major step towards ensuring and assuring a transparent and impartial court. Our corona pandemic experience resulted in bringing the court closer to the public, with high regard to convenience of the parties and time and cost-effective measures. For instance, a physical courtroom setup could easily take more time than the online setup, where the parties would have a sound and video test prior to starting the hearing. Post-pandemic, we still continue online hearings unless where parties request for a physical hearing or when the internet connection is bad or in cases concerning the most serious crimes. Lawyers also enjoy the benefit of going in from one virtual courtroom to another within a matter of seconds. These time-saving measures not only positively contribute to the time management of lawyers, but it also had a positive impact on the management of our workload. The probability of having a case cancelled due to no-show of one of the parties was largely reduced. Overall, I think we were more productive than would have been the case with physical hearings. Maldivian courts are often regarded with some mistrust. The practice of the Supreme Court with the online hearings, coupled with the YouTube and Twitter live streaming, resulted in transparency in how the court worked. We have at least a couple of hundred views of each hearing, so the concerned parties are likely to watch the hearings and know exactly what happened in court. These hearings also reduced unprepared legal counsel to a huge extent. Their clients would, of course, know exactly what happened in court, what was said, and what should have been said. These online hearings held accountable both the courts and the legal counsel to the public. Accusations that previously flew around because of the lack of transparency was pretty much in check. From 2020 to 2022, we had a total of 770 online hearings, whereas the total number of physical hearings within this period was just 126. During these 3 years, we gave 271 judgments online, whereas only 24 judgments were delivered in the physical courtroom with the parties present. During these 3 years, there had only been one case of contempt where a convict did not want the hearing to continue and decided to rest his head on the table throughout the hearing, in spite of repeated warnings from the presiding judge. There were 15 instances where parties were fined for appearing late. These fines are under our general court rules and would apply in the physical courtroom as well. Our experience of online hearings also contribute to the fair and speedy disposal of cases. In conclusion, even though the notion of online hearings without a physical courtroom was first met with some trepidation and doubt, I believe we have reached a point where we can never fully go back to how things were before the pandemic. We have not debunked the physical courtroom and all its traditions, but rather an unconventional method helped alleviate problems related to access to justice. Thank you.